Continuing our series, What to Do If, I have with me famed defense attorney Robert Sheahen. Mr. Sheahen, today I would like you to walk our viewers through what to do if they get arrested, what to expect in court, how long do these things take? Please, the floor is yours. What to do if I get arrested?
If you get arrested, the first thing you want to do is get out of jail. Being in jail not only is personally discomforting, but it also really hurts you legally. A person who's brought into court in custody is much less likely to win a case than a person who walks in wearing a suit or wearing a proper dress. It's very, very important to post bail, the most important thing you're going to do.
So, to post bail, is it an expensive proposition? How much do you have to come up with? In the housing market, very few people can put their house up. How do you do that?
In most jurisdictions, there's something called a bail bondsman. The bail bondsman takes a percentage of the bail. If bail is set at $50,000, the bail bondsman will take a fee of up to $5,000, which is 10%. That fee is a non-refundable fee. You basically burn that, but that allows the bail bondsman to post the $50,000 fee, which gets you out. After that, your obligation is to the bail bondsman to return to court. Property bonds are very rare. As you note, people just don't have the equity. You try to post a property bond for $50,000, you have to have more equity in your house than that, and it's a very complicated system. It's easier just to post the bail bond. In federal court, you generally, in the lower end crimes, you do it by signatures, affidavits of sureties. It's idiosyncratic to the federal courts, but it's actually simpler in the federal courts.
Now, what if the person has the money to post the entire amount? Would you recommend that?
Oddly, I wouldn't. If it's, again, using the number $50,000, if you post a $50,000 bond in cash, it simply ties up your money. You sometimes have trouble getting it back. And the fact that it's there, I've seen instances where other agencies have come in to help themselves to it, whether it be the IRS or the franchise tax or somebody.
Okay, that's a very important tip. Very important tip. Okay, so what happens? You get out of jail, and then what happens?
You get out of jail, and if you don't have a lawyer on board, you get a lawyer. I think we have another video in this series on how to get a lawyer, but get one. Get one you're comfortable with. Get someone who knows what he or she is doing. Get someone who knows the court, who knows the system, and whose fee is reasonable.
Okay, and obviously if you can't afford an attorney, in all states, one will be appointed for you.
One will be appointed. And let me say this, the public defender's office, it many times is maligned. You say, oh, I didn't have a lawyer, I had a public defender. Public defenders are dedicated, good lawyers. If there is a problem, and this is not to diminish anybody, if there's a problem, these public defenders are overworked. So frequently, they don't have the time for a case that a private lawyer would have. It is generally better to have a private lawyer who can devote more time to your case, but many times a public defender will know much more law than the private lawyer.
So a person who can't afford a private attorney should not at all feel doomed that they have a public defender?
No. If you have a public defender, I hate this word, but be proactive with the public defender. And I'm sorry to all the PDs out there for saying this, but ask questions. Ask questions. Make your PD answer the question. No matter who the lawyer is.
Make them answer the question.
Ask the questions and make them answer.
Right. Okay, so now we move to you've got yourself a lawyer, you're out of jail. What happens?
First thing you look to is your arraignment. And arraignment is a first court date. For the arraignment, it's a simple process. It's to enter a plea of guilty or not guilty. You get the question, hey, if I'm guilty, why would I enter a plea of not guilty? A not guilty plea starts the case. It puts it in contest. And that's when you get the paperwork. That's when your lawyer is able to look at the discovery, see the police report, see what mistakes the police made, see if they've got the evidence. Remember, any time you're charged with a crime, the question isn't what did you do, the question is what is the evidence. And if the evidence isn't there, it doesn't matter what you might have done on a moral level. It's a legal question as to whether there is evidence to prove you guilty beyond a reasonable doubt.
So when you hear people say, well, I can't believe that he or she entered a plea of not guilty at their first appearance, they clearly did this. That is a ridiculous statement, correct?
It's people who haven't taken 5th grade civics is what it is. I mean, you enter a plea of not guilty because that's the way the system works. It has nothing to do with I'm making a moral assertion of innocence.
Perfect. Okay, so then you have your arraignment. What comes next?
After an arraignment, in most jurisdictions, you have, depending actually on the charge, let's take a felony. If it's a felony arraignment, in most jurisdictions, you have a preliminary hearing after the arraignment. A preliminary hearing is exactly what the name implies. It's a preliminary hearing to see if there's probable cause to believe that you committed the crime. It's basically a question of, was the arrest legal? Did the police act properly in arresting you? It's not a question of, is there final evidence? That comes up later on. This is just the initial question of, is there enough to get this case started? 90% of the time, the judges rule, yes, there's enough to get the case started.
Right, so our viewers should not believe that their case is going to get dismissed usually at the preliminary hearing. Is that a fair statement? Come on.
It is very rare to have a case dismissed at the prelim. It happens, but it's just very, very rare. This is the time, if you're on the defense side of things, it's a time to see what is going on. It's a time to see what the evidence is. If they do it with live witnesses, which is the way it's done in most places, you see what the evidence looks like, you see what the witnesses look like, you evaluate the case as to whether it is worth trying it. The trial comes up later. The prelim is a very important part of the proceeding.
After the preliminary hearing, if the person is in fact held to answer, what then happens?
The process begins anew in that you then, in many jurisdictions such as California, you have another arraignment, but this is the Superior Court arraignment. This is the trial court arraignment. You get assigned to a trial court, you appear in that court, you again enter a plea of not guilty. It's the same process that has gone on before, but now you're at the trial level, and the case is then set for a jury trial.
But isn't it true that it will not immediately go to trial? There will be other pretrial proceedings, is that correct? And what happens during those?
Yeah, there are various time limits, such as in California. From the time of the preliminary hearing to the time of the Superior Court arraignment is 15 days. When you get to Superior Court, it's 60 days from the date of the arraignment to the date of the trial. Most cases don't take place in that 60 days. It's a very, very rare case where you're either prepared within the 60 days or it's time right. I always say that a criminal case is like a bottle of wine, good wine. You don't open it until it's right, and that is, you don't want to rush to trial. You never want to rush to trial. 3 months, 4 months, 5 months. You need to have discovery motions. You need to have motions to suppress. You need to evaluate the whole case. And most importantly, you need to get the case in a position to be plea bargained. Whether we like it or not, the stark reality is 90% of our cases end in plea bargains. And it's that 3, 4, 5 month period after the Superior Court arraignment where the plea bargain process is taking place.
And again, a case can resolve at any of these appearances. There can be, there's discussions going on throughout the case with the district attorney or with the judge in an attempt to resolve the case. Is that correct?
Any good lawyer begins plea bargain discussions on day 1, and it may take till day 200 for the plea bargain discussions to bear fruit. But yeah, you start at the beginning, and every good lawyer knows that the case is likely to end in something called a disposition, a resolution without trial.